afternoon, and thank you for joining us. I'm Claire Hafner, TCTA's Director of Publications, and I'm joined today by four of our staff attorneys, Lonnie Hollingsworth, Michael Curry, Julie Leahy, and Paige Williams. During the next hour, they will answer your questions about COVID-19 in schools. Please use the Q&A pod to submit your questions, and we'll get to as many of them as we can. Please keep in mind that this webinar is for general information only and does not constitute legal advice. Our staff attorneys can provide legal assistance only to TCTA members with regard to matters arising while they are members of TCTA. As every situation involves different facts and circumstances, our attorneys can provide legal assistance only after they have conducted an interview by phone to determine all the facts relevant to your situation. TCTA members with specific questions should call our legal department at 888-879-8282 for assistance. Okay, let's get started. All right, our first question, a lot of our members have been asking, do teachers have to go back to work? And if they go back to work, do they have to be there during professional development or on campus if the year is starting with remote learning?
We can answer the question or attempt to while you're working on that. This is Lonnie Hollingsworth. I'm the General Counsel of Texas Classroom Teachers Association, and thank you so much for joining our legal webinar today. We understand there are a lot of questions and concerns about the COVID-19 situation in the start of school, and we quite frankly have been trying to figure it out as well as we can and to try to assist you as well as we can. So the question is, why do you have to go back to work? Well, that's not necessarily a legal question. I can answer the legal aspects of it. There are political reasons, there are economic reasons. There's a big push to get schools open again. And there's not a whole lot of consideration to the fact that it may not be safe in some locations where there's significant community spread of the virus. And you know, you're as aware as we are of the various factions and pushing one way or the other. The short answer to that question is, if you have a contract with a district, then you're required to go back to school and go back to work. And we will be discussing during this webinar questions about reasonable accommodations if you have some kind of disability, what the governor's order entails, how long the governor's order lasts, those kind of issues. So we'll get into some of those things. But our entire legal staff has been doing what we can to try to figure out these questions, and we'll be discussing today issues related to the Families First Coronavirus Response Act, which is in effect until December 31st, which provides some leave and some extended family leave. We can discuss the Family Medical Leave Act. We can discuss the Americans with Disabilities Act, and we can discuss issues related to your contract and local absence policies. So that's a good question to get us started. So be glad to go to the next question when you are, Claire.
So the next question is, can we work from home during professional development if our district is starting the year with remote learning? And the answer to that question is you can if your district allows it. So your contract states that you're subject to reassignment by the principal and the superintendent as dictated by the best interest of the district. We believe that this discretion does include the ability to require you to report to work at a specific location or to permit you to work from home. So we think that that is something that is within the discretion of the district, that they certainly can allow you to work from home if they are inclined to do so. We're hearing anecdotally that different districts are doing different things and that they're handling the remote learning in different ways. One thing that we can say for sure is that teachers who have a disability that may make them more vulnerable to the more severe forms of COVID, such as diabetes or hypertension, may be able to request a work from home assignment as an accommodation under the Americans with Disabilities Act. So as a practical matter, many of those work from home assignments have been going to those teachers who do have accommodations and are requesting accommodations under the Americans with Disabilities Act, but certainly the district does have the ability to permit you to work from home, both during professional development and as part of remote learning. To the extent that they do not, that is a choice that they have made.
I would like to add something to that. You know, if your district is doing something like making you go back to be in person for in-services, then that's something you can file a grievance about. You can file a grievance over any condition of work, and it doesn't necessarily have to be a legal argument. The argument can certainly be that there's no real good reason for them to make you go back and do in-services in person if you are able to do them remotely. There's a lot of reasons that have been put forth on why schools should start and why there should be in-person classes and things like that. None of those really apply to things like staff development. So you can file a grievance and just say, look, this is simply not a wise thing to do. It's irresponsible to make people go back in person and be around other people and be close, and where it's difficult to socially distance for no good reason. And you can file a grievance about that. And you can, if you're a TCTA member, we can write your district and correspond with them and let them know in an attempt to resolve it informally, without the necessity of filing a grievance. But that's something that can be done.
And I will add, so TEA guidance, as you all will know, it gives a lot of recommendations. It doesn't give a lot of mandates to your school district, but one of the recommendations for everyone to keep in mind, and you may need to remind your school districts of this, is that any meetings that can be conducted among staff that can be done remotely, they recommend they be done remotely. And any work that employees can do remotely, they suggest that they be allowed to continue to do those remotely. So again, it's not a mandate, but it is something that TEA is recommending as well, and that could also be part of a basis for a grievance.
Okay, I think we've got those video issues resolved, so I apologize for that. Let's get into our next question. I've got one for Lonnie. Says, if a school district asks its employees to sign a waiver to not assume responsibility for if the employees contract COVID-19 at school, would you recommend they sign it?
I would recommend that you call our legal department if you're a member of TCTA before you sign anything like that. First of all, there's no good reason for them to require you to sign a waiver. The district's not liable anyway. And if there is any liability, they're probably accepted from it by the workers' compensation law. They have sovereign immunity. It's very difficult to sue a school district for things like damages from anything. So there's no need for a waiver. And really, if you have a contract with the district, I would argue that they cannot make you agree to an amendment to your contract at this point in time, because they're asking you to agree to something else that's not in your contract. And if you don't have a contract, if you're an at-will employee or something like that, the analysis may be different. But I would still call us before you sign any kind of waiver, because there are some things that can't be waived. And also you may not wish to. On the other hand, the argument can be made, doesn't mean anything, so why not sign it anyway? So these are considerations that you would have to talk to us about and determine whether or not it's a good idea to sign such a thing.
Great, thanks, Lonnie. Now I've got a question for Julie. If you've signed a contract for the upcoming year, can the district decide it doesn't need you due to lack of student enrollment? And can employees be given poor evaluations because they struggle with the technology used for virtual learning, even when the district fails to provide proper training?
Unless you're with a charter school, you cannot just be dismissed outright. School district employees have a contract with their school district under Chapter 21 of the Texas Education Code, and that contract says that you have a job throughout the course of the school year. So one thing I can tell you for certain, you are not in danger of walking into your classroom on Monday and being told, pack your things, get out, you no longer have a job. What districts can do is initiate a process called a reduction in force in the event that enrollment and funding drops too low. That process is pretty lengthy. It does require approval by the Board of Trustees. It's not something that is going to happen without your knowledge. And it does require an opportunity for you to contest what the district is doing. So the short answer to your question is, it is possible theoretically for a district to let people go as a result of a lack of funding or a lack of funds. but it is a process that is public. It is a process that requires them to give you notice and an opportunity to respond. And it's not something that's going to happen just as you walk into a classroom one day. So that's something that hopefully will give you a little bit of reassurance. If you're in a charter school, your situation is different. You are an at-will employee, and you can be subject to termination at any time for any reason. In the event that you do learn that your district has declared a reduction in force or is considering doing so, please contact the TCTA legal department. We can help you walk through the process, tell you specifically what your rights are for due process, and help you go through that process if you are identified as somebody who's going to be subject to the RIF. Appraisals, this is something that we're going to have to address as situations arise. I always tell my clients, and I will tell you as well, if you receive a piece of paper that says that you are anything less than a stellar teacher, that's when you should contact us, and you should contact us right away, regardless of whether it's distance learning or in-person learning, or if it's T-test or what your appraisal system is. If you get something in writing and it says that you're not doing your job to the satisfaction of your employer, then you should call us right away.
And I'll add a comment about appraisals. So one of the things that many of the teacher groups, as included, have asked for moving forward with the COVID situation is that appraisals be waived completely for teachers this year. Now that hasn't been done, so until or if that happens, you need to, move forward as though they're going to do your appraisal. But it is something that we've requested. I know some legislators have mentioned it as well and discussed it as well. So just be aware that that's out there. If you want to contact your legislator, you want to contact the governor's office and advocate that that be something that they consider, that's also an option.
Thank you. Okay, now I've got a question for Michael. Says, it looks like we will be eating lunch in our classrooms with our students this year. Can we be required to do this? And will we lose our duty-free lunch?
That's a good question. The short answer is no. You should not be asked to eat lunch with your students every single day. There's a provision in the Education Code 21405 which allows for teachers to have a duty-free lunch. The thing about this is there is an exception, and I'm not sure it would really apply even in this situation, but in the exception, you can be asked to eat lunch with students, but it cannot be more than 1 day a week. So even in a situation as unforeseen, like a pandemic, you could be asked to eat lunch for the students. However, it can never be more than 1 time a week. And the district cannot invoke that type of exception unless they're still trying to find people to supervise students during the lunch, because TEA has issued rules that interpret this law. And under TEA's rules, you cannot ask, a school district cannot ask a teacher to give up their duty-free lunch and eat lunch with the students unless they're unable to find those volunteers, the community members, administrators from the staff. I mean, there has to be an effort on the part of the district to find people to monitor the students during the lunch before they can ask teachers to do that. And even in that case, it can never happen more than 1 day a week. So this question has been coming up a lot as schools start, that they're being told, teachers being told they're going to have to eat lunch with the students every day, and that's simply not the case. If that happens, you can call us up or write a letter to your district to try and get that taken care of and point out the error of the district ways.
Hey, Michael, just to clarify, I think what you're talking about is a situation in which a teacher is being asked to give up their duty-free lunch in order to eat with students. I do think that what a district can do is say, you eat with your students, say from 12 to 12:30, and then have your duty-free lunch from 12:30 to 1, and then another teacher comes in and watches your students while you're on your lunch. I think as long as you're getting your 30-minute duty-free lunch, you have the ability to cover for other teachers and watch students during a time in the day separate from when your duty-free lunch normally is.
Yeah, if the district is going to give you 2 time periods, they could certainly do that. I think it's unusual that they'll give you 30 minutes and then ask you to supervise your students. But sure, if the district is going to give you an hour and wants you to eat lunch with your students for 30 minutes and then have something where you're free from all duties and responsibilities, they can certainly do that. But yes, it depends on how they structure them.
Okay, all right, next questions. We've gotten several questions about wearing masks at school. What are the guidelines on social distancing and wearing masks? Do we have to wear them even if we're alone in classrooms? And what do we do if we see violations?
I think I may let Julie answer that one, but we've actually been trying to figure that one out because it's unclear from the governor's order. We've been debating amongst ourselves what an Oxford comma means in the particular situation. We're going back to our high school English teachers to try to figure out the grammar rules to it. But I think we've come down to the interpretation that masks are required under the executive order, which we understand has been renewed today, but masks are required while you're inside the school building, and that's our current understanding. Has anybody got a different interpretation? You can see sometimes we have to discuss amongst ourselves what we think the law actually says because it's unclear.
I agree with that. I would also keep in mind that someone specifically asked at what age are students required to wear masks, and the executive order applies to students 10 years old and older, but your school district, your local school district, their reopening plan, their safety plan can require it at a younger age, as long as it is, as TEA puts it, developmentally appropriate. And so different school districts are going to have different requirements about what age they can do. And I agree with Lonnie, just to be safe, I would say that you should just be prepared to wear a mask and have a comfortable mask for 8 hours a day, just to make sure that you're complying. And of course, a district could give you the directive that you need to wear it.
We just had a question pop up in the chat about what about when you're alone in the classroom? And that's the situation that Lonnie's been referring to, that we've been having the discussion about. The actual language of the order says that you're to wear a mask when you're in a public building, comma, or when you're outside in a public area when social distancing is not feasible. So there's been questions about, does that—
I forgot a comma.
Yes, the fatally important comma. The question is, does that portion about social distance being feasible apply to when you're inside? In other words, do you have to wear a mask when you're inside if you are still able to socially distance? And here's my answer to that question. We don't have any specific guidance from any authority as to what that language means. However, the intent of the executive order is to mitigate the spread of the COVID disease. And intent is something that should and can be taken into consideration when you are trying to interpret what a legal document means. There's also, it's unquestionable that the districts absolutely can require you to wear a mask at all times, even when you're in your classroom. So my advice is that it is legally prudent for you to wear a mask at all times when you're in a school district, if in a school building. If for nothing else, if for no other reason, the situation that you want to avoid is one in which little Johnny gets sick and the parent tries to blame you because you weren't wearing your mask. So from that perspective, from the perspective of somebody who is defending teachers, I would feel most comfortable if I knew that you were wearing your mask all the time.
And I would say there was an Attorney General opinion that came out today, and it wasn't specifically talking about schools, but it was talking about the order as it applies to public buildings like courts and things like that in public buildings. And it said specifically, you have to wear a mask while you're indoors. And it didn't talk about the feasibility or anything like that. So it acted like the only thing that really applied were the specific exceptions, like children under the age of 10.
But someone asked about enforceability as well, and so that's going to be a portion of this. Also, is who is responsible for an enforcing executive order. Just know that with executive orders enforcement, it can lead to a fine. First, you get a warning, but then you could get a fine of $250 if that were to be enforced on your campus. And so you don't want to put yourself at risk also to have a monetary consequence. But if other people are not following social distancing protocols or wearing a mask, what is the enforcement provision? And that becomes a little bit more tricky. Again, you have the right to file a grievance. You can point it out to your district that the executive order or the reopening plan is not being followed. But if you are aware of specific instances that are frustrating to you on your campus, I encourage you to give us a call. And social distancing is defined, not those exact words, but the executive order makes reference to 6 feet apart.
And I will tell you, just as a practical matter, what Paige is saying, to call the legal department. You know, I had a situation a couple of days ago where I had someone call me and say that they had gotten the dress code for the professional development that was coming up. And the dress code said that, you know, you could come into the cafeteria, that everybody was going to gather in the cafeteria, and everybody was to take off their masks once they were seated. And that person was upset with that interpretation of the dress code. And we wrote an email to the superintendent, called, talked to the district about it, and they indicated that they would clarify that they did expect you to keep your masks on during professional development. So we view it, you know, even if you don't want to necessarily file a grievance, if you want us to send some communication or correspondence to your district, that's something you don't even have to put your name on. I'd be perfectly happy to put my name on it and say, you know, that this is something that we believe is necessary in order to protect public safety. To the other part of it, if you feel like, you know, a mask should not be required, you know, give us a call and we can discuss that with you as well.
Okay, great. Let's move on to a new topic. This one's for Paige. It says, our district says they are opting not to take temperatures before students enter the school building each day due to privacy concerns. Can a district make this decision? And is it not a state mandate to check temperatures every day?
So it is not a state mandate to take student temperatures every day. In fact, guidance from TEA in their public health guidance specifically says that regularly performing a forehead temperature check of otherwise asymptomatic students in school is not recommended, but the practice is also not prohibited. So your school district could choose to temperature screen all of the students. I think that part of the reason it's not necessarily a mandate from the state is that with students being asymptomatic more often than other people who have COVID, then taking the temperature really doesn't particularly help. And on top of that, there are so many fever reducing products over the counter that are readily available that I think it becomes a question of whether or not it would give you a false sense of security to have the temperature taken. It also creates a logjam upon entering the school. And so you think, you know, drop-off lines are bad. Now, having someone have to take every student's temperature, it's going to just make it even worse. But like I said, depending on the situation, a school district could certainly decide to do so. Instead, what they are asking everyone to do is to self-screen. This includes employees having to self-screen. And so this process does revolve around trusting parents, trusting visitors, trusting employees that they're going to do the self-screen before entering the campus.
I want to add something real quick to the mask question, because somebody asked about eating, you know, taking having the mask while you're eating, and that's a specific exemption to the governor's orders while the person is consuming food or drink.
And I'm going to add one more thing, because people are asking, do they have to supply their own masks? Is my district going to supply me with masks? And so, you know, TEA has ordered 53 million disposable masks, 18 million reusable masks, 12 million sets of gloves, 42,000 thermometers, 600 gallons of sanitizer, and 1 million face shields. And so your school district has enough, I believe TEA said, for 8 disposable masks for every teacher in Texas and 2 reusable masks. But, you know, the reality of the situation is that's not going to last your full year. So just know at the start of the year, they should be able to provide you with PPE. But also, like I said, you're going to be wearing a mask possibly for 8 hours a day. So if you have a mask that you've worn at home that you think is comfortable and you like, then I would suggest using that.
That's great. All right, I've got a question for Lonnie. It says, if I feel unsafe at school this year, do I have any options to protect myself if I don't trust the district's handling of safety protocols and still maintain my employment?
I think I probably jumped the gun and answered that one. I mean, you do have the right to file a grievance over any condition of work. So, you know, if you feel unsafe for some reason, then you need to give us a call if you're a TCTA member, and you know, we'll look at things. We'll look at the guidelines. We'll look to the extent that there are recommendations in there. We'll look to the extent that there are mandates in there. We can talk to you about things like the Americans with Disabilities Act, whether you have a disability that would require reasonable accommodation and whether you can request one. And I know we've gotten some questions. I'm probably jumping the gun here on this one. We've got some questions about how you request a reasonable accommodation. Basically a request for reasonable accommodation is made to the HR department of your school district. And if you request the accommodation, the district is required at that point to enter into what is called an interactive process to determine what kind of accommodation you might need. They can't just say, well, we don't do that. They have to actually talk to you and they have to consider it. And yes, they can ask for medical certification of the disability. This does not give them the right to have a fishing expedition and require you to sign a waiver giving them unfettered access to all your medical records, but they can require you to substantiate the request for reasonable accommodation with medical certification. And if you failure to do so, then you're the one that's not entered into the interactive process because you're not cooperating. So we've had training on these issues, and there are ways to request a reasonable accommodation. Now, can you request a reasonable accommodation? Can you make them let you work remotely? The answer is, I give you a good lawyer answer. It depends. If your job is something that can be done remotely, then that may be a reasonable accommodation. It may be, the district may come back and say, well, we can't do that because you're not fulfilling the essential functions of the job, or that constitutes an unreasonable hardship to the district. There's other considerations such as, if there's a position available that is something that can be done remotely, they may have to consider a transfer to that position. If you think you need I assume most of you have already been dealing with this issue. I mean, the first issue is to go talk to your doctor, maybe to call us first, but you need to get those ducks in a row in order to get the reasonable accommodation in place. And there may be other reasonable accommodations other than remote work. I mean, there may be, there may be something that restricts the number of students you have to see at one time, or that requires all the students to wear a mask or to wear additional PPE. Who knows what it might be, but it's something that has to be the subject of discussion and consideration by the district.
Lonnie, one of the things that we're seeing a lot of from our calls is people who are calling saying, yes, we're doing remote learning, but the teachers are being asked to be in their classroom and do the remote learning from their classroom as opposed to from home. And as to whether or not that's going to be sufficient to satisfy your accommodation request, that's a conversation that you need to have with your doctor. And the way that I would phrase that is to go back to your doctor and say, well, they say I can't work from home, but they do say that I can work by myself in a classroom. Do you think that's enough protection for me given my medical history? And have that discussion with your doctor, and then you can come back to the district and talk about specifically what your needs are.
Okay, great. All right, next question. This one is for Paige. Member says, I'm on a Title I campus and the demographics of our district reflect a high percentage of students of color. Data shows that minority communities have been affected disproportionately by COVID-19. Do the CDC guidelines or TEA take this data into consideration when opening schools as a whole? And would they consider a campus by campus plan?
So I'm not going to speak for the CDC or TEA because I have no idea what they are thinking of and what is on their mind when they take this into consideration, but we would hope so. That being said, TEA guidance and CDC guidance gives your district a lot of autonomy about reopening for better or for worse. And so I know that one of the things that Commissioner Morath has discussed is districts having discretion to kind of do a reorganization of campuses, so to speak. So what the state is requiring is that a parent have the option to send their student to in-person learning after the start of school transition period is complete. And Commissioner Morath has specifically said that some campuses could be remote only as long as the parents of students zoned for that campus who want in-person instruction have the option of putting their student on another campus that has in-person instruction. So, that could be one way that your district structures it. That being said, I haven't seen any district plans who have done this, but there's over 1,000 school districts and each have their own plan. So if you have suggestions for your school district on something like that, now is the time to be discussing that with them and offering that as an option.
Okay, I've got a question for Julie. If a teacher meets the retirement qualifications but did not plan on retiring before COVID-19, is it too late to submit documentation or start the process before school begins? Will there be penalties, and would I be eligible for rehire?
Let's talk about the retirement piece of that question first. Yes, you can still retire. You are going to miss out on the monthly annuities that you may have received had you completed the application for retirement prior to June 15th, but you are still eligible. As to the question of will there be penalties, again, you won't get that annuity. Will I be eligible for rehire? Technically, yes. I will tell you, it is increasingly unusual for teachers to re-enter the profession after they have retired. We don't see nearly the amount of rehire that we used to see in the old days, just because of the fees associated with rehiring teachers who have entered the TRS system. So yes, you are eligible for rehire, but in your planning, you should probably plan for the fact that you may find it more difficult to get a job once you have entered the TRS system than you might otherwise have had you not entered the TRS system.
I would say that in order to rehire for more than just half time, you have to completely be away from the profession for an entire year. And if you come back, you can't volunteer, you can't do anything for a school district for an entire year. And then after that time, yes, the district can hire you back and you can work full time, but the district is required to pay TRS for the costs of contributions to TRS and for TRS care, and that's an extremely costly proposition, and a lot of times they pass that through to the teachers.
Thank you for that clarification, Lonnie. You said it better than I did.
I'm going to start letting you answer the TRS questions.
No. I'll pass that on to you.
Okay, now I've got a question for Michael. If you are live streaming your class while other students are present in your classroom, do those students need to have parental permission to have their likeness broadcast for FERPA?
So that's a, go ahead.
Go ahead.
Oh, I was going to say, it's an interesting question that came up a lot. In the spring, because as everyone on this call is aware, school districts pretty much shut down for March and didn't open up for a couple of months, and a lot of them are still going remote. Now that, FERPA is something that teachers and districts should be aware of. If a concern is getting filed, a lawsuit gets filed, the cause of action under FERPA is going to be against the school district. It's not against the individual teacher or educator in this situation. It's actually against the school district. As far as the permission to have the student's likeness, there is an exception in the Texas Education Code when you're dealing with audio video recordings. There's 4 exceptions, media, co-curricular activities, but the press coverage, and one of them that's really is important in this case, it's something that relates to the regular classroom instruction. And so I think it's a pretty good argument that, this in-class remote learning is something that's going to be, part of the regular classroom instruction in the COVID world that we're now in. But, as far as a general idea, obviously don't discuss any, FERPA protected information, on these calls or in front of these students. But the safe course of action, is to obviously have a waiver from the parents. But that should be something the district should be sending out, because ultimately the district's on the hook if there's any type of a FERPA violation.
Now I will say the the U.S. Department of Education did put out some guidance in the spring, basically saying that streaming classes was okay.
Yeah, I believe that what that guidance said was it's similar to as if a parent walks into your classroom. It's the same kind of thing, that if they're watching your video stream or they're watching your class from the viewpoint of confidentiality protection, it's the same as that teacher, that student, that parent had walked into your class.
Yeah, and I think that from a practical matter, we need to be careful that if you're recording this, that it's on a closed network, that it's not gonna be publicly available. You know, you don't put it on the district's Facebook page of all the individual teachers in their classrooms. You know, if you're going to do that, if you want to have the protection of the classroom exception, it has to be kept within that same parameters. You cannot be publicizing this. You can have a dedicated closed network where someone can access it if they need to after it, but it cannot be publicly available, or else that will be the violation.
Good point.
All right. Okay, next question. If we contract COVID-19, do we need to use our own personal days to get coverage, or will the state provide districts with a COVID-19 fund?
We have several answers to that one. Michael, you've done such a good job of the FFCRA. Why don't you explain that one?
Yeah, I'm happy to do that. So just quick little background here. The FFCRA is the Family First Coronavirus Response Act. It came about in March of this year, went into effect April 1st, and it's only into effect right now until December 31st. So there's a limited time that this law is in place. But the thing about the FFCRA is it modified a couple of different provisions of law, and it gives employees the ability to take some type of paid leave up to 80 hours, and you are not going to have to use your accrued state or local leave. And that's really important, because a lot of the other laws that are out there, if it's FMLA or TDL, they are unpaid, but you can use your accrued leave days. But with the FFCRA, it provides that individuals for 10 days, 80 hours to use, and it's paid leave. It doesn't come off of your accrued balance, your leave balance, and you obviously have job security during this time. Now, what becomes an issue if someone has to take longer than that 10 days or longer than the 80 hours. And that's where you're going to run in a situation where you're no longer on paid leave under the FFCRA once you're out of those first 80 hours or 2 weeks. So you're eligible to take longer period up to, an additional 10 weeks under the FMLA provisions, but that's unpaid. But if you have accrued sick or personal leave from a state or local level, you would be able to use that, assuming you would meet the qualifications and the eligibility for FMLA, which is, generally speaking, you have to have worked in the employer for a year or 1,250 hours in the preceding 12 months.
So
just to clarify, it is not 10 days every time you need it. It is a total of 10 days. So yeah, unfortunately, if you were to get sick twice, you don't get an additional 10 days. That's when.
And that's one of the problems with this law, is that it only gives you, it assumes everyone's either going to only get sick once, or they're only going to get sick for 10 days. And that's it. So that's a big problem with the law. I mean, I think when it came about in March, it was obviously a difficult time from a federal level and from a national level, and you had Democrats and Republicans come together in this political environment. That's kind of a rarity these days, but they came together and they passed this bill, which is it's kind of unprecedented at a federal level to provide that paid leave, because FMLA, when it came about, under President Clinton in '94, it wasn't paid. And so this thing came about as one of the first instances when you can have paid leave from a federally mandated level, which is kind of a unique thing about the FFCRA. But yeah, Paige, you're right. Having only 10 days, that's definitely a flaw in the law.
Well, and you also have to remember that back when this thing was adopted back in March, that's what everyone thought. You get COVID, you're down for 2 weeks, and then you come back. I mean, that's kind of what everybody thought. And it wasn't until, more recently that we've gotten more experience with it that we've learned that some people do get it again. Some people do have it for longer than 10 days. We're learning more about the virus, but the law has not caught up with that. And the other thing that I think that we should note here is that the law does expire in December, at the end of December. So, you know, even if you, let's say you don't get it at all in the fall, and then you get it in January, unless it's renewed, that protection is not going to be there for you at all. So one thing that we would encourage you to do is follow our updates, particularly as Congress comes back into session. We definitely will be talking a lot about, you know, FFCRA renewal and what that's going to look like as it's being considered by Congress.
Now,
Also, look at your local school district policy, because some school districts are doing more or giving more leave or making more paid leave available for employees given the circumstances. So, you know, and they have that ability in board policy. So take a look at your board policy, see if it's changed over the summer. I don't think that is broad. I don't think a lot of school districts are doing this, but, you know, your circumstances may be different. So look at your board policy and also call us.
Yeah,
Now,
one question that came up in chat, if I want to clarify on this, the full pay that you get for that 2-week period, obviously if you're sick with COVID-19 symptoms, you're eligible for it. An employee can also get it if they're unable to work or telework because you're subject to an isolation order or quarantine pursuant to a federal, state, or local governmental order. So you can be subject to quarantine under the FFCRA, and you would be eligible for that same 2-week period of paid leave. So you can use it for a quarantine reason. And I know that question came up in chat just now, so I wanted to answer that.
And we think that would apply if your school district sends you home. Like, say, for example, one of your students gets it and tests positive, and they tell you, well, you have to go home and you have to quarantine for 2 weeks. We consider that to be a local order to go home and quarantine for 2 weeks, and we believe that you'd be covered under the FFCRA for that 10 days.
So in that circumstance, they may make telework available for you because the whole class might have to stay home.
Yeah. And if so, you wouldn't have to use any type of leave whatsoever. You would be paid as though you're reporting to work.
and we also think that you may contractually be entitled to be paid if you're feeling good and ready, willing, and able to work, and you have a contract. You know, we would argue, well, they have to pay you, but that depends on the specific circumstance.
Okay, that's great discussion. We've gotten several questions today asking, can districts or schools require teachers to clean, sanitize, or disinfect areas and objects throughout the school day?
No one jump in.
No one wants to answer that one because there's not a clear answer. You know, we don't think that's really part of the professional duties that's in your contract of a teacher or a professional. If you are a teacher or a professional, we would argue that needs to be done by, you know, someone who's trained to disinfect. I mean, your janitors, your custodial staff are going to be familiar with the chemicals. They're going to be trained on how to use them. They're the ones that should probably be doing these things. Again, it may be one of those things that can be subject to a grievance, and probably there's some compelling reasons to argue that shouldn't be done. I mean, you know, some minor wiping down and stuff like that I can kind of see, but you know, to be the one that's responsible for disinfecting and the workplace, you know, I think that goes beyond what should be expected.
And Lonnie mentioned something called professional capacity, and I'd like to elaborate a little bit on what that means. So you have a contract as a classroom teacher, and your classroom teacher duties, everybody knows what a classroom teacher does. A classroom teacher gets up in front of the class, they instruct students, they do lesson plans, they assess for mastery, they do grades. These are the things that a classroom teacher does, and these are the things that you agreed to do when you signed your contract. That's what professional capacity means. So the law around professional capacity basically says that they can't make you do things outside of this role as a classroom teacher without changing the terms of your contract. And where we commonly see these kinds of, you know, disputes is when, you know, you're an assistant superintendent and you get busted down to an assistant principal. You know, does that violate the terms of your contract? And there's been a lot of litigation, and some of it has said that yes, it does. So in this case, your argument is basically, I'm a classroom teacher, I'm not a janitor. And so being, you know, cleaning is not within my professional capacity. And so that's basically what a professional capacity argument means. And I do think that you have a good contractual argument to make. Now, you have to make that argument through the grievance process. So if you think that this is something that you want to complain about specifically, I know we've had some questions from, for example, women who are pregnant and are concerned about the chemicals associated with some of the cleaning products that your district is using. And if you want to talk about that in more detail, I would encourage you to call us, particularly if you think that this is something that you might be willing to file a grievance about. We can help you with that part of it.
Okay, we've gotten several questions today too about if a teacher decides not to return to school this year over concerns of COVID, can the district or the state take actions against their certification if they resign without permission? You know, like, should they be concerned with getting their certification revoked if they quit their job?
So they can, but I will put a few things out there. First of all, this is something that we've actually written a letter to Commissioner Morath about, asking him for some guidance about allowing concerns about COVID and health concerns to be more affirmatively recognized as good cause for leaving a contract. So I just want to put that out there, that this is something that we have asked for. And depending upon this situation, I don't know that school districts are necessarily agreeing to release people from their contracts due to their concerns, but they certainly can. If they refuse to release you from your contract, you know, some districts are also making the choice not to necessarily report to the State Board for Educator certification right now, given kind of the unprecedented circumstances that we're in. And so that's something that you may want to discuss with them as well. And then it comes down, and I'm going to let Julie talk about it. She knows a little bit more about it than I do, about some of the good cause reasons for of being able to mitigate or avoid a sanction on your certificate.
Okay. Thank you, Paige. What Paige is talking about is, generally speaking, you have to have the district's permission in order to resign. But the laws does set out a couple of exceptions. And the most important exception for purposes of COVID is that it is considered good cause to abandon your contract if you have a compelling health reason, or if there is a member of your family who has a significant health condition that might require you to resign. So basically what that means is that if you need to resign, for example, because you have a spouse or a child who's got a significant health condition and you're concerned about their exposure to the virus, you're afraid about bringing it home, and you haven't been able to negotiate a work from home assignment, and so you're thinking about resigning, that provision may apply to you. The big caveat on that is that what they're going to expect if you resign under that provision is that you actually stay home to be with that, to be a caregiver to that person. It's not gonna work if, for example, you take a job at a school district that's closer to home that allows you to spend more time with your sick family member. They're gonna want you to actually be a caregiver to that person on a full-time basis. I think the same analysis would apply if you are resigning for your own health reasons. If you have one of those significant health conditions that we mentioned earlier, you're unable to negotiate something with the district that you feel protects you and keeps you safe, and you decide that you want to resign. I do believe that you have a good argument to make that you have good cause to resign from your contract under that provision, but you need to make sure that you flat out resign and you don't go back to work somewhere else, especially at another school district. That's going to make a big difference into whether or not you're able to claim the protection of that provision. The other provision that could potentially give you good cause to resign is that you can resign from your contract with good cause if something unforeseen has happened that has substantially changed your life, basically. That's kind of a catch-all, and TEA used it back when Hurricane Harvey came through to say that teachers who resigned from their position because they had been displaced from their homes due to Hurricane Harvey had not abandoned their contracts because they had to go live somewhere else and couldn't come back to their district. In a similar way, if, for example, you lose childcare or you lose your housing as a result of the COVID pandemic, and that causes you to have to resign from your job, you may potentially have an argument that you have good cause to abandon your contract there. So those are two provisions that could apply to protect you from sanctions. As a general rule, if you think you are going to resign from your contract and you've talked to your district and they're not agreeing to release you, call us and call us before you resign, and we can talk to you about some ways to potentially negotiate and work with your district. We got a question in the chat that I want to take a look at that I think was about this just now.
And Julie, before we leave that, one thing I want to mention as far as the resignation and the good cause is that you really want to work with your employer to see if they're going to release you. All those things that Julie is mentioning about good cause at TEA, so a lot of that is predicated on you already being reported to the state, you potentially having a 1-year suspension of your teaching license, which is what the sanction is. The typical sanction is your license is suspended for a calendar year, so it will almost always involve 2 school years. But to get that release, you really want to get the district to sign off on it up front, because if they do, then you're not having to argue good cause at the state level, and because it's an unknown. And if at all possible, you really want to avoid being reported. So try and work with the district and secure the release is what you should try and do.
There also may be some other options, such as you may be able to take a Family Medical Leave Act leave, FMLA leave, which if you have a serious health condition or you need to take leave to take care of another individual, a child or an adult child under guardianship, or a spouse or a aged parent or something like that, you may be able to take FMLA leave for up to 12 weeks. That is generally unpaid leave unless you have local leave that can be applied. So that's one option. Michael mentioned TDL leave, and that's leave of absence for temporary disability. That's something else that may be considered. So there may be other options to a resignation. And also, for that matter, under the Americans with Disabilities Act, you may be able to ask for unpaid leave as a reasonable accommodation. That's another reasonable accommodation that may be considered.
So we got a question on the chat of what are health issues that are good arguments that you should be able to resign or request accommodations? And the answer to that question is that's a conversation for you to have with your doctor. Basically, what the EEOC has said as far as the Americans with Disabilities Act is concerned is that you may be entitled to accommodations if you have a health condition that could subject you to the more severe forms of COVID. And the typically recognized ones that you hear about a lot in the media would be things like diabetes or hypertension. But there are, we're not doctors, so we don't know all of the health conditions that could potentially subject you to the more severe forms of COVID that make you more vulnerable. So if you think you might have a health condition that could put you at risk, make an appointment with your doctor, tell your doctor specifically that you're a teacher, you're worried about your exposure, and get feedback from them as to what you might need in order to be safe.
And we've gotten a lot of questions about pregnancy and how it applies to the Americans with Disabilities Act. I mean, generally, a normal pregnancy is not a disability under the Americans with Disabilities Act, whereas a high-risk pregnancy could be. But who knows what it is nowadays when any pregnancy could be considered high risk because of the presence of the virus. So these are questions we just don't know, and something that you have to go through making the request for accommodations or look into FMLA leave or something like that, and we just have to figure out how it plays out.
We've had a couple of people ask on a different topic. Is it okay for schools to allow face shields instead of face masks? And I believe the answer to that question is yes. What is recovered is a face covering, and it does not limit itself to face shields or face masks. And in fact, there's been some discussion that face shields may be a better tool from a developmental standpoint for either small children or children with disabilities who connect better with you when they can actually see your facial expressions a little bit better. So yes, you can wear a face shield.
Good point.
Your district could direct you to wear a mask.
Correct, unless your district actually directs you to wear a mask. But most of what we've seen, at least what I've seen anecdotally, says face covering, which is generally interpreted to mean a face shield as well.
Right. I will point out that TEA, bought however many 53 million masks. They only bought 1 million face shields. So that means that you would more than likely be responsible for procuring and ordering your own if you want to use face shields, and districts are more than likely going to be holding on to them to use them for students for which it would be better for their accommodations for special education teachers and the student's IEP, and for those students for who it is more developmentally appropriate to be wearing face shields. So you may have to buy them on your own, and I don't know how easy that is But keep in mind, this is handy dandy. TEA guidance actually put out a list of every approved vendor for PPE that they have available for districts. So you could actually try and talk to your district about contacting an approved vendor and reaching out and procuring more, but your district would have to expend the funds instead of the state.
So somebody asked, can your district require face shields instead of masks? And the answer is, yeah, probably so.
We haven't seen any districts do that. So, most districts are adopting the face covering language that is used by TEA and the CDC.
Okay, we're getting close to 2 o'clock, but I think we've got time for one more question. We have a member who's asked that their district, specifically their campus, has a hard time during a regular school year getting enough substitutes. So sometimes they have to cover other classes with more than 30 students at the same time as their own classes. Can this be required during this year with COVID? And what happens if your classroom isn't big enough to be spaced 6 feet apart?
I'm only going to take the second part of that question, which is there's not a requirement that your students be spaced 6 feet apart. That requirement is if it is possible. And if it's not, then they have to wear, then if they're 10 or older, they need to wear masks. And we would say at any age, if they have to be closer than that, then, you know, arguably they would need to wear masks. So, so just know, I just want to dispel anyone from the belief that your desks have to be 6 feet apart, because that's just not going to be feasible in some classrooms, in some districts, and some facilities. But in that case, the students should be wearing masks or a face covering. Sorry.
Well, that was a short answer, so I think we've got time.
We didn't
We didn't answer the first part. Who wants to take
that? To be honest with you, I think we're avoiding it because we know the answer and it's too horrible to contemplate. If there aren't enough subs and there aren't enough teachers, I mean, I can only assume that they're going to divide up the classes and just ask teachers to cover. As to whether or not that's going to happen during, is your principal going to come to you and ask you to cover for other teachers during your planning time? Probably. We don't think that that's legal. As you know, if you're not getting your 450 minutes as a result of that request, that is not a legal request. But we anticipate that request will probably be made of you. And if you don't want to do it, you should call us and talk to us, and we'd be happy to communicate with your district on that point.
I will point out some districts, as part of their District of Innovation plan, have exempted themselves from the planning and preparation requirement, unfortunately. And
yeah, that's one of the things that we can check on as to whether or not I'm sorry, Lonnie, I'm interrupting you.
Go ahead. Now, that's something we check on. I mean, whenever anyone asks about a planning preparation question, I immediately go to their DOI plan to see if they've exempted it. There's not many of them, but some do, and some of them may get the bright idea to do it. So you know, that's something to watch out for if your district starts talking about amending its District of Innovation plan. I mean, they could take away any of this stuff, so it's something to be cognizant of.
But yes, we do anticipate that subs are going to become an issue this year, and that there are going to be shortages, and we expect that districts will try all kinds of creative ways to try to cover. And the best I can say is if a request is being made of you that you feel is unsafe or makes you uncomfortable, or you feel it violates your right, call us and we'll talk to you about the specific situation.
Great. Well, we are right here at 2 o'clock, so I think that's going to be all the time we have for questions today. Again, if we didn't answer your question, or if you have a specific question with a situation in your district that you'd like to talk to one of our attorneys about, our members should call the legal department at 888-879-8282 for assistance. Thank you all for joining us today. Thank you, Lonnie, Michael, Julie, and Paige, for taking time to answer our questions. We have a lot more information on our website about COVID-19 and returning to school, including some videos, lots of resources to TEA guidance. You can find all of it at tcta.org/COVID-19. We'll also be sharing a recording of this session on that site soon. Thank you all so much. Enjoy the rest of your day and stay safe as you return to school this year.